Webster's dictionary defines hyperbole as describing something better or worse than it actually is. So what we are going to see over the course of the next 48 or 72 hours is more hyperbole than people can possibly imagine. But let me just point out a few of the claims that have been made under other opportunities to continue the hyperbolic rhetoric, which we're going to see today. I remember during Act 10, my colleague from the 64th said in a release that this is going to permanently hurt people. It's going to bankrupt school districts. We would have more teens get pregnant. We would have more risky outcomes. We would have higher infant mortality. In fact, all of those are down since our bill passed. We heard when we talked about the Castle Doctrine, you called it the right to kill. That is hyperbole and exaggerated rhetoric. When we passed early voting reforms, you said it would limit the freedom of Wisconsin citizens and make it more difficult for people to vote. But the reality is that if you look at the 2014 elections, election turnout was higher than it was in previous years after our bill passed.
For what purpose does the gentleman from the 43rd seek the floor?
I'd like to make a point of order. Earlier, you stopped our leader from talking about something you felt wasn't before us. Act 10 is not before us today, Mr. Speaker.
Mr. Speaker, point of personal privilege. For the Speaker to come and impugn our reputation, I'm going to respond. And I have that right to respond because his point about hyperbole and mentioning how the sun is shining in Wisconsin, everything's rosy, and how great it is. And he mentioned specifically, Mr. Speaker, Act 10 didn't hurt anybody, nobody lost their insurance, education's better, worker protections are still in place. Mr. Speaker, I just briefly, and I don't want to drag this on, but I just want to remind the Speaker, you know, in the homes of people you don't talk to, that $6,000 that came out of their paycheck has desperately hurt people, Mr. Speaker.
I guess we do live in two different worlds, especially when I listen to the comments from the Speaker of this body. I traveled the state as part of the Rural Schools Task Force to hear exactly the problems we have with education as a result of Act 10, and I can tell you it's not so rosy in rural Wisconsin. We can't attract teachers. We can't attract civil servants to jobs that are unable to be filled. So when I hear people saying that everything's rosy, it's not so rosy out there, Mr. Speaker. We have a lot to do in this body. We could work on fixing the financing for rural schools, our school funding formula. But instead, we are creating exceptions in the law for politicians. And that, I think, is what disturbs me the most about all of this. It's because I understand your side of the aisle benefits from cynicism toward this body and towards the good work of government. That is what I think is so ultimately cynical about everything. You benefit when they think we're all a bunch of crooks. Because then people get disgusted, they don't vote, they turn away from the system. And I think the best way to say this is when there is apathy, you allow evil to rule. And you benefit from apathy. You benefit from cynicism. Instead, and I want the press to understand this, when these past couple days end, you will know which party in Wisconsin believes in clean, open, honest, and transparent government and which side does not.
The gentleman's 2 minutes have
expired. Thank you.
And if you think that we have hyperbole on our side, perhaps you think Judge Easterbrook from the 7th Circuit is full of hyperbole when he reversed Judge Randa's throwing out of this John Doe. And this is what Judge Easterbrook, a Reagan appointee, said. Starting with Buckley versus Vallejo, the Supreme Court has stated repeatedly
Without objection, you may read from a printed document
yes,
from time to time.
Thank you. The Supreme Court has stated repeated that although the First Amendment protects truly independent expenditures for political speech, the government is entitled to regulate coordination between candidates' campaigns and purportedly independent groups. This is not First Amendment, folks. This is not about the First Amendment. This is about stopping this kind of collusion. And Judge Easterbrook reasons if campaigns tell potential contributors to divert money to nominally independent groups that have agreed to do the campaign's bidding, these contribution limits become porous, and the requirement that politicians' campaign committees disclose the donors and amounts become useless. That's what this investigation was about. There are decades of law saying that states can prohibit this kind of coordination. It is not protected, Mr. Speaker, and this is where the gentleman from the 63rd is absolutely wrong. This has never been protected by the First Amendment until this state Supreme Court that's bought and paid for by Club for Growth and WMC, who never should have heard this case in the first place, said that it was. In fact, Judge Easterbrook, the Reagan appointee, who I guess is full of hyperbole, said, no, in the same decision, this is a recent decision, no opinion issued by the Supreme Court or by any court of appeals establishes that the First Amendment forbids regulation of coordination between campaign committees and issue advocacy groups.
I want to just go back to the speaker's comments to some degree as well. Everything's great in Wisconsin. Boy, we're just doing awesome. Our schools, our roads, jobs. Do you really believe that? Really?